Good afternoon, everyone. My name is Darren Sall. I'm an associate at Samfiru Tumarkin's Vancouver office. Thank you for joining me today for this half-hour question and answer session on Facebook and YouTube. I practice both in employment law and disability law, and I'm here to answer all of your employment or disability questions today. No question too big or too small. Well, there may be one or two that are too big or too detailed, but we'll get into that. But no question too small. Ask any question you may have been thinking about, for current employment, past employment, questions you might have about future employment. And same with disability. And if you're on a current claim, if you think you may be heading towards a disability claim, hop on here. This is your chance to ask any questions. In a no hassle, no commitment environment. You can always contact our offices if you've got a matter that's maybe too personal, or there's a lot of detail involved that you don't want to share online. Completely understand. Feel free to contact our offices. You can visit us at www.employmentlawyer.ca. We've got resources there. We've got contact links, so you can get a hold of our intake team. We've got intake people who work across, BC, Alberta, and Ontario. We provide assistance in other provinces as well. Give us a call. I practice in BC and Alberta primarily. Feel free to reach out if you want to speak to me or anyone else in our team. Our next session online, I'll get this out of the way first, is Ontario, and that would be Lior Samfiru, the employment lawyer himself, will be answering your questions Wednesday, October 19th, and that's 1 p.m. Eastern time. And so feel free to pop on if you have any Ontario questions on Wednesday at 1 p.m. Eastern time to talk to Lior. Otherwise, you can feel free to pop on today and talk to me. We've got many sessions. We've got recorded sessions on our websites, www.employmentlawyer.ca. There's blogs on there. We've got just a ton of topics for you guys to scroll through. That may answer some of your questions. You may read through some stuff there if you want to get some general employment knowledge or disability knowledge. There's also disabilityfaq.ca, I believe. And you can go on there, and there's a bunch of questions, frequently asked questions that relating to disability claims, where you can go on and just scroll through. Reading the information, you may find questions that you didn't even know you had. And so I've got a couple things that I have teed up to talk about while we wait for. Oh, we actually got a question coming in here already. That's great. So I'll pop off with this, and if we have any kind of lulls throughout the broadcast here, I'm going to be talking a bit about group terminations. If you guys do have topics you want to hear about, you can feel free to like and subscribe on our Facebook and YouTube, and you can make requests if there are sessions you do want to hear about. That's totally fine. We can look into that as well. So we have a question here from Debbie. Debbie says, my son has been working for a contract company for Bell for over 16 years. He's entitled to 5 weeks vacation a year, which he is never allowed to take. They do not pay out the amount per year, so much so that he has a vacation balance on his paycheck of almost $5,000. Currently, he has a health issue that is keeping him from working. They do not pay sick leave, and he could use that money. Yet previously said that he has to go on EI or short-term disability under these types of circumstances. This is a great distress and seems totally wrong. As they are under the purview of federal employee due to Bell controlling the contracted company, what are his rights? So, Debbie, there's a lot to kind of unpack here. I'm going to do my best to unpack it online here, but there's a couple different things that are going to come into play here. If your son, so let's break this out. If your son has a health issue that is entitling him to disability leave, my advice would be probably to explore that to start. They can pay out his vacation balance if he requests it, and they should be paying that out, kind of yearly. But if they're not, and there is an amount there, he can request that to be paid out. If he does have a health issue that's keeping him from working, and there is no paid sick leave for his position with them, the contractor does not have that. and he does have a short-term disability or long-term disability policy, then he needs to go to his doctor and he needs to apply for that right away. If his doctor supports him being on short-term or long-term disability, that's what needs to happen. I think that's probably the best course of action for now while you sort out, there's a couple different things that will hinge on this is what type of a health issue that is keeping him from working, how long that's expected to be around, what type of work he does, and what part of the contracting their company does. So if it's involved in telecom, if he's federally regulated, there are different rules for federally regulated companies such as Bell. If the contracting work he does is, let's say integral to Bell's operations, then that company may be federally regulated as well. If they're only doing provincial stuff and if it's not integral, there's a number of tests that will come into play to determine whether or not federal regulation applies or provincial does. We'd have to know who the contracting company is. I think, Debbie, what you'd be best served to do is have your son go to the doctor, get on some type of short-term disability. If there is a policy in place that he has access to, hop onto that, contact us. And there's a couple things to unpack here. Like I said, I do both employment and disability law. I'd want to see both of the contracts, the employment contract, the disability contract. And so that's something that we talk about in our disability law radio show. And you can go onto our website, employmentlawyer.ca, and you can hear past iterations of the radio show. I know one of the partners and I, Martin Willems, and I talked about this recently, and it was looking at the terms of the contract. This is something we always go back to with an LTD policy, a disability policy, or an employment contract. When that's in play, we always go to the terms of the contract. That's going to control the policy in the cases of long-term disability. So what type of disability benefits they have access to, in which conditions they're paid. And so if you get a copy of that, get a copy of the employment contract, contact us for, a free consultation. I think there's a couple things to unpack here with your son's situation, Debbie. And I'd encourage you to call us so we can kind of help set you up and, on the right path, to make sure that he's protected moving forward, both in his employment and with a potential disability claim. But so he has the time he needs to get better, from whatever health issue is ailing him. I think that's the right course to go on. So hopefully that answers your question a bit, Debbie, enough to maybe get you on the road to, on the road to what you need to do right now, but contact us and we can definitely give you a hand. And so we have another question coming in off Facebook. This is from Emily, and Emily asks, my employer laid me off at the beginning of the year because I have not been fully vaccinated. They have now terminated me from my position and stated that I am not owed any severance because I failed to comply with their policies. Is this true? So, Emily, this is a great question, and it's one that obviously has been a hot button topic since the COVID pandemic has plagued us. There's been a couple decisions, and I'm going to assume for the moment, and just for the purpose of this question right now, that you're in British Columbia. I'm not sure exactly where you are. There are differences between the provinces in terms of the laws and some decisions that have come out. There was a recent decision that came out in British Columbia, and where our firm is tackling that right now. When it comes to the terms of your termination, one thing we would want to see always is the termination letter. If you were placed on an unpaid leave, depending on how long that has been, you said at the beginning of the year. So under the Employment Standards Act, there, especially in cases of COVID, if you're placed on a leave for an excess period of time, and it changes depending on when you were placed on the leave and for what reason. Typically, it's, I believe, 13 weeks out of any 20-week period. And when you're placed on a leave of that length, you can be deemed terminated by operation of law unless you agree to the leave. So in this case, if you've agreed to the leave, or if you've accepted the unpaid leave, and that they've now terminated you, and it's a without cause termination, to me, it's not clear. I think based on your question, it seems to me you may have been terminated for cause if they're saying you breached their policies. And my view on this, I mean, this is a contentious position, and there's back and forth in the law on this right now. But my position on this, and I think it's supported by the current case law that's out, is that a with cause termination may not be supportable, and is not supportable in these situations. You can terminate someone for failing to adhere to a policy, but you owe them severance. And I think, in this case, it's important to get the specifics of your situation. Again, Emily, it's to contact us. If you have an employment contract, what your entitlements are will really be dictated by the employment contract if you have one. If you don't have an employment contract, then there are a number of factors which we look at to determine what your severance entitlements may be in that situation, or what they are in that situation. So I would say give us a call, Emily. We're happy to talk to you, and we're happy to um, um, give you some specific and tailored advice to your situation. This is a topic that we've been dealing with, for the past 2.5 years, 3 years almost now. So facts do matter here. The specifics do matter. What type of work you're in, the industry you're in. I mean, these are all very important considerations. For example, if you're in a healthcare industry or a healthcare setting, as opposed to a remote working marketing position, the analysis can be very different. And so please do give us a call. Talk with one of our lawyers. I'm happy to speak with you myself. You can go on the website. All of our contact details are there. If you're online right now and you've got a phone, I think my QR code just handily popped up there. You can scan that, and it'll put you in touch directly with me, with my contact details. And I'm happy to speak to anyone who comes on here on a more personal level, privately, about your matter, and to give you some help there. So we have another question that came through from YouTube, from Martin Knight. Martin asks, can an employer take away vacation days as a disciplinary measure? So Martin, that's a great question. Generally, no. It really depends on what your vacation entitlement looks like. There is a minimum standard set out in the Employment Standards Act. It is based on your years of service, and it is based on what's called a vacation accrual rate. So, for example, if you're employed for less than 5 years, your accrual rate is 4% of your salary as vacation time. So if you make, $100,000 a year, you get the equivalent of 4% of that as vacation time. That is vacation time that is owed to you. If you're there over 5 years, it's 6%. And so as long as if you're contractually entitled to vacation days, your employer can modify those depending on the terms of your contract. Again, this always goes back to the wording of your contract. But when it comes to your employment standards minimums, if your employer is trying to take those away from you, that is something that they cannot do. Those are minimum entitlements guaranteed to you by law. So if that happens, then, come and talk to us. There may be some actions you can take. You can also contact the Employment Standards Branch and lodge a complaint with them directly. That's one measure for you to go. I would simply talk to your employer, and just to maybe explain that to them. As odd as it may be, there are employers out there who are not aware of minimum entitlements. You can direct them to us as well. Information never hurts. And so you're more than willing, to talk to them about that. You're more than able to talk to them about that. Let's see. So hopefully that answers your question, Martin. We have another question coming through from YouTube, and that is Marcus. Marcus asks, my disability insurer just sent me a letter stating that they would like to send me for an independent medical assessment. I'm not sure why they are doing this or if I should go. I've already sent them my reports from several doctors. What should I do? So, Marcus, that's a great question. I could probably do most of a session on this question alone, but I'm going to try to give you a little more of a straightforward answer. So, with any disability questions, we're always going to go back to the policy. A disability policy is a contract. It's a contract of insurance coverage for you. And so it's a contract you've entered into with the insurer, or your employer has entered into on your behalf with the insurer. that policy or that contract dictates the terms of your coverage. It also dictates what the insurer can and cannot do. For example, many policies will have a term somewhere in there which says at various times the insurer can send you for an independent medical assessment. If that is contained in there, then yes, you would have to attend. Um, if that is not contained in there, then the analysis becomes a little more nuanced. If, for example, they have a bunch of medical information and they're simply seeking additional information, it may be warranted. It may be reasonable. But again, the necessity of you going, the ability of them to force you to go, is going to be determined by the language that's in the policy. So we always look at the policy first. In your case, I'm going to assume that it does say that, they are permitted to send you for an independent medical assessment. If you refuse to go, if you refuse to honor the terms of that contract, they can deny you. Okay, they can deny your claim. Now, the reason they're sending you for that independent medical assessment could be there. There could be varied reasons. Typically, why they send you for this is you're not getting better. Your doctors or the medical reports you've sent them don't indicate any kind of favorable prognosis, and maybe don't indicate any clear treatment path. So they may be sending you for a little clarity and to maybe give you a little bit of direction. That's the positive side of me thinking that. The more the side of me that maybe looks at this a little more skeptically is they're looking to cut you off. They're looking for a reason to cut you off. They're sending you to an expert that will be able to say, Marcus is not as disabled as he seems. He's able to do some type of work within the meaning of this policy. He's not totally disabled, and therefore, he can go back to work in some capacity. They'll then use that as a reason to cut you off. So I would say, if you're doing the right thing right now, you've got questions. This is raised, the hairs on the back of the neck there to say, okay, what's going on here? There's this doesn't feel right. This doesn't seem right. I've sent the medical information. Why are they looking for someone independent and separate from my treating practitioners? And typically, I will say typically the insurers do this as a way to preface a cutoff. So you've done the right thing. You reached out to us today. You asked the question. Get in touch with us. Call me. My QR code was up before. You can go on the websites. You can contact us, employmentlawyer.ca, if you're in BC and Alberta, or Ontario, Manitoba, Saskatchewan. If you're anywhere, give us a call. Send us your contract of insurance, your disability contract. We're happy to read it over. We do a free consultation for you. You don't lose anything by contacting us, and having a chat about this. Minimum, you'll know your rights. You'll know what you can and can't do. And in this case, Marcus, you will likely be required to attend the assessment, but not. It's not a guarantee. And just because you sent them your doctor's medical information, you will likely have an obligation to do that as well, to send medical information and to give them access to that under the terms of your policy. But they, if they have the right for an independent assessment, then that is something you would have to submit to. But again, contact us, because we can talk you through it. We can kind of tell you what to expect, and we can make sure that you're protected and that what's being done is being done in the right way for you and for your claim and under the terms of the policy. And so Martin's got a follow up here. When you say totally disabled, what does that mean? I've heard it before. So again, that's a great question, Martin. And that goes to the terms of your policy. When you look through your policy, there'll be a short term. And so the policy booklet you have, there'll be a booklet and there'll be an actual policy. The policy is usually 100 plus pages. And that's the one you want to look at for the appropriate definitions. And there'll be a section that says short-term disability and a section that says long-term disability. And there'll be a definition section as well. Long-term disability will be described in there and defined in there. And so it's generally the same definition, but it can vary policy per policy. But generally, there's two phases to long-term disability. There is, and again, this is general. There are specific policies which modify this, but generally there are two phases to being totally disabled. There is a 2-year period where you're disabled from your own occupation, performing the essential duties of your own occupation. And then typically 2 years later, that changes to you are disabled from doing the essential duties of any occupation that is kind of at your level of commensurate experience and training and education. So other jobs that you would be able to do. And so if your doctor says, for example, if you are a heavy equipment mechanic, and your doctor says, okay, you've got, rotator cuff, back and neck injuries. You could sit at a desk perhaps, and maybe work on a computer for 2 or 3 or 4 hours a day. But you can't do heavy equipment mechanic work. You would be in that situation, you would likely be defined as totally disabled under that policy for your profession. So like anything with any long-term disability claim, it is rooted in the contract. So you always go back to there, you read the definitions, it'll have what the insurer can ask you to do or require you to do, and it will have your obligations in there as well, such as, submitting to appropriate medical treatment, following medical recommendations, being under the care of a doctor continuously. These are all things that will be contained in the policy. So if you ever have questions about your policy, obviously you can always just come and ask us, send us your policy. We'll do the hard work for you. We'll review it and we'll have a call with you and let you know what you're obligated to do and whether you're getting the entitlements you should be getting. There are situations where people are owed benefits that under their contract that they're not being paid. And sometimes you just find that out by giving us a call, having us review it. Like I said, you don't lose anything. You gain, knowledge. If nothing else, you gain knowledge about your current situation and your policy. Okay, so Martin and Marcus, hopefully that covers your questions. If you have additional ones, feel free to ask them here. If you've got specific ones, like I said, give us a call, send in your policies, and happy to take a look over them. Okay, we've got another question here from Samantha. Samantha is asking a question off YouTube. Samantha's asking, my employer has told me I'm getting a promotion and is asking me to sign a new contract, but I see that it states that I'll be put back on a probationary period. Can they do this? If they let me go during the new probationary period, am I not entitled to any severance pay? So, Samantha, that's a great question. This is something that happens, quite regularly when people are given promotions, changes in title, compensation, or whatnot. Is often the employer will ask them to sign a new contract. And I'm assuming that since you're saying you're signing a new contract, you've got an existing contract. What I typically recommend people to do is to take a look at your existing contract, look at your new contract, compare them. See what the differences are. Sometimes you'll see differences like Samantha has where, okay, you had a probationary period before, but now you're being put one on again. You may see differences in termination clauses. It would behoove you in these situations to do exactly what Samantha's doing and reach out, get an informal opinion, or send us the contract, contact us and get an actual opinion on what they can do and what the changes to your, new contract are going to do to your employment and your rights, in your employment and on termination. So Samantha, what I would say is talk to your employer. Sometimes they give out standard contracts which just contain a probationary provision. I've seen this quite often where they just standard contract, they send it out to you. It's not edited at all for you. So they may not be intending to put you on a probationary period. Clarify this first, because if you sign a contract which still has that in there, you will be agreeing to it, and you will be setting yourself out as being subject to that probationary period and the terms of that probationary period. And so generally in a situation where you're signing a new contract, your years of service and whatnot will apply to ensure you get severance commensurate with your years of service and whatever restrictions are placed on you in your employment contract. In this case, if they're placing you on a new probationary period and that probationary period allows them to terminate you within a certain amount of time, this may be termed as new employment. It really depends on how the probation came about. Generally, no, they cannot terminate you without providing you with zero severance. If you've been there for a period of time, over 3 months, you're owed, at minimum, you're owed employment standard severance. In your situation, what I would do is I would talk to them and just say, hey, listen, I get this as a promotion, but I've been here for X number of years or months or whatnot. Are you really intending to put me back on a probationary period? And see what they say. It may just simply be an oversight. And if that's the case, have them remove that provision before you sign the contract. 9 times out of 10, I would say for people I talk to, that's typically what the response from the company is, oh, standard contract, didn't intend to put that in. Let's take that out. So if you can avoid that, that's great. If you can avoid a fight, if you are terminated, that's great. And if you've been somewhere and they're making you sign a new contract, one thing you may want to ask an employer to put in there is recognition for previous years of service. So not only to do something like take a probationary clause out, but to put in a specific clause saying, so-and-so company recognizes your X number of years of prior service. Just to make it clear, it's not necessary, but if you're really, making some alterations to the contract, it's not a terrible thing to have added in just for some certainty. With your position, Samantha, I'm also going to assume you're getting a raise. Typically, when you do sign a new contract, there is some consideration that has to pass from one party to another. So in this case, Samantha, it's either going to be a raise, I assume, from you, or it's going to be the new position. That they're giving you the promotion in exchange for you signing this contract, provided you sign it before you start that position. So hopefully that answers your question, Samantha. We have another question in, and I see we're getting short on time here, so I'm going to try to run through a couple here. We have another question in from Kara. So if anyone else has any questions, pop them in as quick as you can here, and I'm going to try to get to as many as I can. Kara from YouTube. Kara asks, I've been working night shift for a few years now. I'm returning to my job from maternity leave and cannot work nights any longer. Can my employer refuse to change my shift? And if so, what can I do? So that's a great question, Kara. And I think it depends on, my answer is going to depend on why you can't work night shift any longer. If it's your choice and you're making that demand of your employer, they don't have to create a new position for you, but they are required to bring you back, especially from maternity leave, to your old position or a similar position. Okay, and so they'll be required to bring you back to a night shift position or a similar type of position. If your employer just does not have any other positions available, so for example, no day shift positions. So let's just say you're a nurse and you're in a private setting and your employer's bringing you back from a maternity leave and there's no day shifts available and you cannot work night shift anymore. That may be a position, that may be a time where they just terminate your employment and you collect your severance and then you go on your way. Really it's going to depend a little on the details here, well, quite a bit on the details here as to why you can't work nights any longer and what the reason is for your employer's refusal to change your shift. If there are other shifts available and they're just not doing it, then that you may have a ground for discrimination based on family status or whatnot, because you're returning from maternity leave. If they're refusing to accommodate you, so the other half of this is the employers have a duty to accommodate you when you're coming back from things like a maternity leave, or if there's a protected disability ground, physical disability or mental disability or something like that. In this case, because of your the fact that you are coming back from maternity leave, they'll be required to make some accommodations to you. And so if there are other shifts available that would fit with your schedule and they're just refusing to give it to you for no reason, then you'd likely have a human rights claim against them. So I would say contact us. Let's get some more details. Let's nail down what your possible options are. You definitely have some kind of recourse. We just have to kind of determine where that recourse sits, what the best avenue for you is. Okay, and hopefully that answers your question, Kara. We've got little time here. Julie asks, can you please post the answer for the question regarding the independent medical assessment for the person who's on disability from the insurance company? I might be in the same situation. So Julie, if you go to our website, there'll be a ton of resources on our disability law website, and you can contact any one of us. My QR code's in the bottom. You can contact me directly. You can visit us online. I think the website's popped up there at stlawyers.ca. And we will have, that answer as well as other ones posted in our disability law section. And again, if you're in the same situation or a similar situation, Julie, give me a call. And if you're in Ontario, then you can pop on and contact any one of our Ontario associates or partners. You can also give me a call and I can just pass you over to someone. But get in touch with us, send us your contract of insurance, and let's have a talk about your situation. Unfortunately, the 30 minutes seems to have gone by quicker than usual today. I'll be back in 2 weeks to answer all of your employment and disability law questions. It's a pleasure to speak with you guys, and thanks for the great interactions today. If you find this useful, everyone, and tell your friends, like this, subscribe. This is a service we provide. I'm always happy to answer anyone's questions. Get in touch with me directly, or follow any of my colleagues. We have a ton of these on every week. I look forward to speaking with you guys all at some point. Take care.